like to also thank Andrew Griggs for the opportunity to come out and speak to you. Andrew's from the Department of Commerce. Just to give a bit of background, skilled migration versus family migration are the two major factors for permanent migration in Australia. And as you can see over the years, we've got figures dating back to 1984. You can see that huge expansion that really started to kick in 2001, 2, 3, and then up now. The skilled sector represents about 68% of the permanent migration program at this point, whereas the family stream represents 31.7%. That extra 0.3% is taken up under the humanitarian banner. Now, yes, just as this is a bit of an overview as to the people who are here as migrants who are able to work for you, and I've separated them into various sectors. That permanent residents, people who hold a permanent residence visa, are able to work full time. Okay. Now these may be people that have come here on a spouse visa. They may have been people that came out on family visas a long time ago and now hold a thing called a resident return visa. There is no issue with you skilled migrants. I'm going to run through this fairly quickly. Temporary residents with work rights. Now, you will come across people. You can't hear me, I'm sorry. Is that better?
Oh, yes.
Okay. I'll try to keep this close. You can find people who are partners and family members of primary 457 visa holders. So if you've got a skilled worker who's here, he's been sponsored under the 457 temporary visa program, they may have a spouse, they may have working age children, dependents, who are able to work. And but once again, under the normal industrial relations laws, they must be paid in accordance with the way that you would pay any Australian. But these people have got the capacity to work. You may also find partners of students. That gets a little more complicated because students and their partners can only work 20 hours a week during semesters. I don't know if you'd see many students out here, but it's possible you might see them travelling. If they've got a student visa, 20 hours a week during semesters, they can knock themselves out in semester breaks. They can work as many hours as they choose. The next area, the working holiday maker. Now, there are a couple of visas in this category. The one that you're mainly going to see is the 417. It's available for these people. If they hold that 417 visa, you can employ them full-time for a period of up to 6 months. They cannot work for you for longer than those 6 months. However, if they hold a 417 visa and they're working in regional Australia during that first 12-month period, and they work in either mining, construction or agriculture, which also includes aquaculture, they could be eligible to apply for a second 12-month visa. If they apply for it and they're successful, they could come back to work for you for a further 6 months in their second year. Now, from that visa also, it is a launching point for somebody if they wish to sponsor them in under one of the permanent programs or even under the 457 program, provided we agree and also the person meets the eligibility criteria. The really important thing here is that as an employer, it really is incumbent on an employer to ensure that the person has work rights. There are a lot of people out there who are seeking to work who are on visitor visas, and visitor visas are a no-go area. So as an employer, we would definitely recommend that you go onto our website, register for VIVO. It's a visa entitlement verification online. You get a special number, a code that allows you to access, and with the permission of the applicant, you can get in there and find out whether or not they've got work rights. Do not employ anybody who doesn't have work rights. There are pretty severe penalties, and there are also sanctions that could apply that could impact on you as a sponsor later on. Now I'm going to look at some of the range of options that are available. You'll probably all see a little bit more detail on that later. Labour agreements, they've become a a bit of a political issue, particularly in the enterprise migration agreement area. I'm not going to go there at this point, but I'll talk about labour agreements later. Then you've got the regional migration scheme, which is, these are permanent visas as opposed to the 457, which is a temporary visa. But the regional sponsored and the employer nomination scheme are very similar. The employer nomination scheme is highly prescribed, however. There is a list of occupations that you can sponsor. If the occupation is not on that list, it's a no-go area. Whereas under the regional sponsored, we take a much broader look. And if anybody here is familiar with ANSCO, the Australian-New Zealand Standard Classification of Occupations, it becomes our Bible in terms of whether or not you're able to sponsor somebody in. So if you are familiar with it, I'll mention the indicative skill levels 1 to 3 are the areas that you can look at any occupation. If it's outside of that, then you may get the opportunity through a labour agreement. I'll go into that later. So we've had some changes in this area of the ENSR-SMS program. There was a review back in 2009 for the 457 program, which changed some of the eligibility criteria. It certainly tightened things up. There was to be a review of the permanent program directly after that, but however, a lot of other newsworthy issues in the migration portfolio came to the fore and delayed it. We've gone through a review and implemented changes as of the 1st of July this year. So there's some pretty major changes in particularly where RSMS is concerned. Some of the eligibility criteria has shifted, but once again, I'll move into that in a second. Bottom one down there, skilled independent. That comes under our general skilled migration program. It's where people are able to sponsor themselves in, or with the assistance of state government body, are able to pick up enough points to sponsor themselves in. Australia has a shortage of skills in recognised occupations. There's a list that does change probably on a yearly basis, and this list determines whether or not a person who's qualified in that occupation, whether here or as an international student or overseas with experience in the field, are able to accumulate points, meet a threshold, and then be invited to lodge an application to sponsor themselves in. And there is a crossover there with employers, and I'll move into an area called Skill Select towards the end of this presentation. But firstly, we'll go back. We'll look at the 457. It's temporary and demand driven, so we don't have a cap on this, and it can be actioned very quickly. If you as a sponsor provide us with a decision-ready application, so all of your eligibility criteria is met and the eligibility criteria of the applicant is met, we can process these things in 5 days, which is pretty remarkable because about 3 years ago it was taking us something like 12 weeks. So it's highly responsive. People who now are able, through the 457 program, and this is part of the review that happened with the permanent program, there was a disconnect. We had a 457 list of occupations. We also had this list of occupations that you could sponsor in. And some of the occupations on the 457 list did not exist in the permanent program. So people came here with an expectation that they would transition from temporary to permanent, and they were unable to do so. So this review that we've had recently has come into effect. So now, instead of a 457 list, there's a thing called the CSOL. It's the Consolidated Skilled Occupation List. It's available on our website, and it applies to the permanent program and to the 457 program. We look at the 3 steps. We look at you as an employer and your capacity to sponsor somebody in, so you'd be required to provide financials. We would look at your history with the department to determine whether or not it was adverse and how long you've been operating. We need to get details down. We look at the nomination, which is the occupation. We call it a nomination. Does it exist on the list? If so, and you've ticked the box, yes, you can sponsor somebody in to be a mechanic or whatever occupation. The next thing we look at is the applicant themselves and whether or not they meet the criteria. Now, under the 457 program, there is no age criteria. It's all to do with skills and English. There are exemptions for people undertaking or having to undertake the IELTS, which is the International English language testing system. The threshold on that, back in 2009, moved from a 4.5 average to 5 in each of the 4 streams. Now, if you come from the UK, the US, and it was the same back then, New Zealand, Canada, and Ireland, you don't need to sit the test. If you're trying to sponsor somebody in and they don't meet the test, but you're paying them more than $92,000 as of the 1st of July, you've got to seek an exception on that. Okay. People will have to undertake, unless they've been working here previously on a 457, they'll have to undertake skills assessment. There's information about where to go and how to go about it. Just move on to the permanent reforms. We used to have 6 visa categories in the RSMS ENS environment. That was for offshore and onshore and labour agreements under those programs. Now there are 2. We're going through a visa rationalisation program at the moment, so by the end of next year, a lot of visas that are out there in common will be folded into other visas with various streams. So we've also streamlined the path from 457 to permanent visas. So if somebody's worked on 457 in the same occupation for the same employer for 2 years, there's a fast streaming. They don't have to resit an English test. They don't have to go through the skills assessments. However, there is the age criteria. One of the things that happened here also is the upper age limit. It used to be up to the age of 45, and then you are able to seek exceptions, exceptional circumstances on somebody who was over that age group. It was a subjective process that's been taken out, but we've raised that to under the age of 50. So if somebody's 49 years, 11 months and 3 weeks old at the date of application, they are eligible. Once they hit 50, it's a no-go except for certain circumstances. I'll get into that in a second. The English language, which used to be a 4.5 average for RSMS, has now been taken up to 6 to align with the ENS program, which has always sat at 6. So each of the 4 streams now, instead of an average of 4.5, it's now 6. It does create problems for certain people from certain countries where they may have actually spoken English. People from the Philippines in particular, many of the tradespeople may have an English learning background, but generally speaking, they have difficulties even getting to the 4.5 in general. I know it's improving, but that's the way it sits at the moment. We've focused, under the RSMS program, there's a requirement to go and seek certification from a regional certifying body. You have one here, the RDA in Kalgoorlie. And we've basically trimmed it down. So if somebody's transitioning from 457 into the permanent program, they meet those criteria. They've worked for you for 2 years, etc. I've just previously explained. You go and need certification to go through that, and there goes the mic again. Sorry. Or if it's a direct entry, if the person's offshore or they're on some other kind of visa other than 457, that will require regional certification before you come to us. And I've already mentioned the consolidated list. So looking at those streams, the temporary transition scheme I've explained, that's 457 into permanent. The direct is people who are on any other kind of visa, or even a 457, they may have been working for you for a year and you've decided to sponsor them in. They haven't met that 2-year criteria, so you've got to take them in through the direct entry, which requires regional certification for that purpose. And then we've got the agreement stream. Back in September 2011, the West Australian government lobbied very, very strongly with the federal government and was able to secure all Western Australia as a region. So previously the metropolitan area was not a region, now it is. And so is therefore eligible under the RSMS program. There's a copy of this for you to take home. So this is pretty much a bit of a comparison as to the way these things work under the stream. So I don't think I'll go into that. The next slide as well is likewise under the direct entry stream, the similarities and differences between the two. Now, I did talk about exemptions, age and English. Under the age program, if you've got a worker who's been working for you for the last couple of years or 4 years, it may have been ongoing, and they're getting close to that critical age where they would not meet the temporary program, i.e. 50 years of age. If they've crossed that line, if they've been working full-time for you for the 4 years on the 457, and they're paid at the Fair Work Australia high income threshold. Now this at the moment, it's indexed, but at the moment it's about $123,500. So if you've got highly skilled people and you're paying them more than that, and they've been on that, over that threshold for the past 4 years, and like I said, it was indexed. I think the previous year it was, well, about 3 or 4 years ago, it was about 118,000, but each year it creeps up. The English exemptions, I mentioned, they're the countries that the applicant may come from. There is also another exemption for those being paid a salary of more than $180,000 per annum. So maybe an exec coming out of 451, an exec being sponsored out under the permanent program. We're going to get into labour agreements. Now, these are contracts that are set up between you as an employer and the department. They exist for companies that are trying to bring in workers for on-hire purposes, in say the ANSCO category or indicative skill levels 1 to 3. It may even extend to an indicative skill level 4. But and it's the only way that a non-hire company, i.e. a company that brings people in, they pay their salaries, but they service other industries by sending those people out to work in their direct workplace. It also allows an employer who is not able to access a particular occupation, and an argument needs to be put to the department about this, but if it's indicative skill level 4 and you're trying to bring somebody out in that, under that, our programs don't work except for a tailor-made, a bespoke program just for you. It's called a labour program, a labour agreement. So where these genuine skill shortages exist, we will analyse it, we will look at a submission. It doesn't cost you anything to engage in putting the submission together. And we certainly have them considered. In some industries, there are actually templates for them. And I'm not sure what the demand here would be for skill level 4. Yes?
Hello, Robert. With the agreements, is there anywhere within that agreement, has it got provisions of employing, if you get someone from overseas, you must employ an apprentice? If you get someone from overseas, is that where this will actually fit?
It would depend on your industry.
Metal trades.
Okay. What we would be looking at, we will all, under the 457 program, one of the requirements for an employer is to expend money on the training of Australian citizens or permanent residents. Okay? There is a provision in there. If you don't have an apprentice, that's okay, but we would be seeking somewhere between 1 and 2% of your total salary expenditure to be spent on training of Australians or permanent residents. If you don't spend that directly in your website, and this has to be done through an RTO, you can't undertake it yourself unless you are an RTO. If you have apprentices, their salaries can be offset against that particular training benchmark.
Is that widely publicised? Because that's the first time I've heard about it, and I'm an RTO.
No, but look, it is if you read deeply into, if you drill down into the labour agreement information that's on the website, there are mentions of it. But this will always come up because the labour agreement is sort of like horse trading. You're seeking concessions, the department's going to come back to you and say, okay, we'll give you this. We might give you a lower English criteria. We might give you, yes, this occupation because it's an indicative skill level 4, but we're going to ask something from you, and that's this. And that more often than not is reflected in expenditure and training of Australians. Now, if you don't spend it yourself, you can actually, and under the 457 program and also under the permanent ones, because, well, ENS in particular, you must, if your financial evidence doesn't indicate that you've spent 1% of your total salary packages on training Australians, we will ask you to put 2% into an RTO and provide us with the receipts. So you could donate that money to local TAFE, any kind of RTO, registered training.
I'll give you my name.
I'm sorry?
I'll give you my name.
Okay, I'll give you my card. And but once again, this comes through from in the submission. Submission is protracted. It used to take 18 months to put one of these things together. We can get them done in 3 to 6 months these days. Our labour agreement area has expanded immeasurably over the last 2 to 3 years. So we've got a lot of people in there working on them, and it seems to be a bit of a trend at the moment. You might have heard of regional migration agreements. They're a bigger environment. It's where a defined geographical boundary has been recognised by the department, and there are organisations within, it could be a CCI, it could be other industry bodies that take over the pastoral care and negotiation process on behalf of a group of employers. And it might be every industry within a region. So it could be, there's some agriculture, there's mining, there's construction, there's whatever industries. Those occupations are pretty much put together as certain, you might need X number of mechanics, so many boiler makers, so many farmers of one kind or another, machine operators, there could be any of those sorts of things. And the companies wishing to sponsor are all identified. So, as part to this, when one of these things comes together, you as an employer, once the department is agreed, and once again, we look at the English, we look at the skills, we look at age, all of those sorts of issues. If it's a permanent visa, and we can do permanent labour agreements, there's similar sorts of criteria applied. But once again, concessions can be granted. But you as an employer will come in under the umbrella of a particular regional migration agreement and say, I need 2 of these, 3 of these, 4 of those, and you take on the role as the sponsor. Now, I know I've got to move, so I will be available for a while to speak to you. I will be available all day tomorrow if people want to come and see me for a half-hour consult. And thanks to the CCI, I'll be down there. Certainly appreciate that. A little bit more information. Skill Select is where people from overseas can put their CVs up, and you as an employer can actually access that list, and you may be able to engage somebody who's seeking to migrate to Australia. You then connect directly with them. It has many other purposes, but that's one that's of significance to employees. There's a bit of information here about websites. This is available